If you wanna be solicitors, why don't you come and visit us at SQE TV?
In a recent video on SQE TV, I highlighted that one of the significant areas for underperformance by candidates in SQE1 was in relation to dispute resolution questions. So we've got one dispute resolution question here that I've answered against the clock, and I've actually managed to do it in less than 60 seconds. For details, stay tuned, but only after the jingle.
SQE TV.
Can I answer this dispute resolution question in less than 60 seconds? Here goes. A solicitor is acting on behalf of a claimant in a claim against a local firm of accountants. The claimant's claim is that she acted on negligent advice provided by the defendant. All appropriate pre-action procedures have been followed and proceedings have been issued and served. The solicitor receives an email from the firm of solicitors acting as the defendant which explains that the solicitor who had conduct of the matter has been absent from the office due to ill health. The firm has filed the acknowledgement of service with the court on behalf of the defendant but requires an extension of time in order to prepare and file the client's defence. The claimant solicitor agrees to an extension of 7 days for the filing of the defence, and the court is notified in writing. On the date that the agreed 7-day extension period is due to expire, the defendant solicitor requests a further extension of time for filing the defence. What's the maximum further extension, if any, which the claimant solicitor can agree? Well, this is easy. It's Rule 15.5, CPR 15.5. It's 28 days in total. They've had 7 already, so it's 21 days, which is option C. Stop the clock.
SQE TV.
So what we're going to do now is to do, as we always do on SQE TV, is to break down the question into little bite-sized chunks and share with you my internal monologue. What was I thinking about as I was reading the question and processing all the information, and show you how I arrive ultimately at the right answer, which was, I'm pleased to say, option C. We got the right answer, as usual. So, looking at the question, a solicitor is acting on behalf of a claimant in her claim against a local firm of accountants. So just sense check there, we're acting for the claimant, not the defendant, and it looks like it's litigation proceedings, dispute resolution. The claimant's claim is that she acted on negligent advice provided by the defendant. All appropriate pre-action procedures have been followed and proceedings have been issued and served. So yep, definitely looks like a dispute resolution matter. The solicitor receives an email from the firm of solicitors acting for the defendant, which explains that the solicitor who had conduct of the matter has been absent from the office due to ill health. The firm has filed the acknowledgement of service with the court on behalf of the defendant, but requires an extension of time in order to prepare and file their client's defence. So this is something that's quite common. I'm thinking, oh, this is all about service of documents and possibly extensions of time. And indeed, this is confirmed by the next few paragraphs. The claimant solicitor agrees an extension of 7 days for the filing of the defence, and the court is notified in writing. And just as an aside, it's very common for parties to agree short extensions of time for service of documents. A claimant will routinely allow an additional 7, 14, maybe more days for service of a defence, provided that the defendant comes up with a decent reason for the ongoing delay. It could be complexities, it could be absence of the relevant fee earners, but something genuine that explains why they can't get their act together within the 14 days that they have for service of the defence after filing of the acknowledgement of service. So, what does the next part say? It says, on the date that the agreed 7-day extension is due to expire, the defendant solicitor requests a further extension of time for filing the defence. What is the maximum further extension, if any, to which the claimant solicitor can agree without the permission of the court? And as you look down all the options there, you can see that there are various amounts of extension of time that we have to work out, or what is required. And to get this right, you needed, as I mentioned when I did this against the clock, you need to have an understanding and remember what CPR 15.5 provides, and then apply that to the facts of the question. Now, 15.5 says that parties can agree an extension of time for the defendant to file their defence up to 28 days without the consent of the court. So no permission of the court is needed if extensions of time are agreed between the parties up to 28 days. And this rule does not say that it has to be one extension. It can be several extensions. It doesn't have to be 28 days at a time. It could be 7 days at a time, or 7 then 14, or 7 then 21. It doesn't matter as long as it doesn't exceed 28 days in total from the first request by the defendant. So applying the facts of the case, we were told, if you looked at the fact pattern, that one extension of time of 7 days had been granted so far. CPR Rule 15.5 tells us that you can agree up to 28 days as the claimant solicitor, so there's another 21 days in the bag. So they could agree up to 21 days further extension of time without the leave of the court. Of course, they don't have to agree 21, they could agree 7 or 14. And obviously, if they don't agree, then it goes to a hearing and the parties argue the case in front of the master in the High Court, or if it's in the county court, in front of the district judge. I did a lot of that when I was a trainee solicitor. It was one of the ways that I managed to cut my teeth as an advocate in relatively low-level applications, but it got me confident on my feet in court. So the answer definitely was C, because that says 21 days is the maximum amount of additional time that the parties could agree.
SQE TV.
As regular skewers will know, skewers being regular SQE TV viewers, as you will know, what we always do after we've been through one of the sample questions and given you my internal monologue and the correct answer, what we now do is to share with you a few what-if scenarios, because of course you're never going to get this exact question in the SQE1 assessment, but the same point of law could be examined, albeit on slightly different facts. So, what if scenario number 1? What if the claimant and the defendant had already agreed a full 28-day extension for the defendant to serve their defence already? What if they were perfectly prepared to agree between themselves a further 7-day extension? Is that something they can do without the permission of the court? Clue, the answer is in CPR 15.5. Alternatively, what if it's the first request for an extension of time? Does the claimant have to agree, bearing in mind what the provisions are of CPR 15.5? Or scenario number 3, what if the claimant's prepared to give a 7-day extension, but the defendant is seeking a 21-day extension? How does that get resolved? And finally, you could be tested on what the consequences might be if the claimant was deemed to be unreasonable in refusing the request for an extension of time by the defendant. And this will all be about exposure to costs, of course, in the various MCQ options. So there's a few MCQ variations for you to go away and research and consider. And if you've got those in mind, the chances are you should be able to answer any question that involves an interpretation and application of CPR 15.5. Anyway, I hope you enjoyed this video. If you did, please do tap that notification bell, because if you do that, you'll find out as soon as similar content gets delivered onto our platform. And please do leave a comment if you like this video. Let us know if there's any particular content or maybe another question in the SRA's question bank you'd like us to cover. And as we always do, when we finish an SQE TV video, we say, it's now time for the jingle.
If you wanna be solicited,